because they might be running into a huge opposition from communities because of the negative impacts that they are causing, right? So today, protecting an investment is very much about properly managing those risks. So if I want, and if we think that the protection of investment is there to guarantee that the investor takes the business, takes the activity, can carry on the activity, and can benefit economically from the activity, if this is the idea of protection, then we need to integrate in this idea of protection the idea of managing human rights risk. So here I'd like to draw you to the question of the treaties, because I think it's very interesting what is happening with investment treaties. So in investment treaties, these investment treaties were first designed in 1959. The first investment treaty came about in 1959 between Germany and Pakistan, right? And at that time, when these investment treaties, afterwards, there was a time in the 60s, there were very few treaties signed, but then the boom of those treaties came in the 80s. And the idea behind those treaties was protecting the investor from political risk, right? And these are the risks that states take a measure that affects the investment, right? So it expropriates the investment, it nationalizes the investment, it decides to terminate the license. So these are political risks that the investors take, and these treaties were designed to protect investors from political risk, right? And this is basically the only purpose today of those treaties. Now, if you think today about protecting investment again, the protection it is not only about protecting investors from the political risk and what the government can do, but it is also protecting the investment from those environmental impacts or those negative human rights impacts that can put an end to the operation of the business. So that's why it is very important that we start thinking about how these treaties that were created and designed for protecting the investor against political risk also integrate the idea of protecting the investment in this respect and on managing human rights risk. So in the space of investor contracts, we have a guidance with the principles for responsible contracts, but in the space of treaties, we still need to do a lot of thinking around how to do it. Because the way in which these treaties are structured, I mean, the structure itself of the treaties might be the one that is preventing the thinking around the protection of investment in terms of managing the human rights risk. So it is not only with a clause, it is not only with a sentence in the preamble around the protection of human rights or something around these terms that is going to guarantee that the investment treaties would also integrate this part of managing human rights risk. And here it's important to remember that these treaties are absolutely silent around the responsibilities of investors. So these treaties only impose obligations to the states, but they're absolutely silent about the responsibilities for investors. And that's where we need to really start thinking about how we make these treaties coherent with our other efforts in terms of regulation, policy, and state investor contracts to also get investors to manage the risk at this level too, right? This is the idea that the protecting investment should include the adequate management of human rights risk, and that should be reflected around the regulatory framework, but also the regulatory framework needs to provide the guarantees and the elements to it needs to provide the elements to have human rights guarantees. And this is, for example, in terms of land. So the regulatory framework, and that goes beyond purely investment, but the regulatory framework of the state needs to have certain clarity, for example, around land. Because having clarity around the title of land, the use of land, right, would help actually the investor better get into the operation, get ahead with the businesses without having then the problem or the interference around actually this land belongs to a community, to an indigenous community that belongs to someone else, and then there's going to be a problem for the investment. Yeah? In the country, for example, Colombia, what we saw that was, and probably is also a challenge here around land titling, about customary ways of having use or access to the land. And what we have in Colombia is also a challenge with displaced communities. So if there is not a strong framework there guaranteeing what is the land title, then it's going to have an impact on the development of investment activities. The idea also is then that instruments like due diligence are introduced in the tools. So due diligence, and Andrea explained that, I mean, that's all around the principle for responsible contracts. And the other element is what, as I mentioned before, is access to remedy. So access to remedy and having a way to deal with claims from people that are affected by these investments is very important for the stability of these investments. If I don't have as a community a channel for my claims, I'm going to look for ways of doing that. I'm going to manifest, I'm going to demonstrate, I'm going to block the road, I'm going to block the factory. So something is going to happen to actually voice my discontent, right? So you better have remedies and access to effective remedies in order to avoid these things to happen. The other element, and we have mentioned that, Andrea mentioned that extensively for the investor contracts, but we need to think about that in the other spaces, is that of maintaining the adequate regulatory space. So it can happen not only in the stabilization clauses that Andrea mentioned, but it also can come in the investment treaties. And that's where we are seeing now, and that's one of the main concerns around, as I mentioned, around the TTIP negotiation, is how these treaties are preventing the state to regulate in the public interest, including the fulfillment of human rights. And it also can come in legislation. So again, this exemption for investors could also come in legislation. In Colombia, we have something called the Stabilization Law, and this Stabilization Law allows the investor, actually gives the investor the possibility to sign a stabilization agreement. So it's not a clause within the agreement, but it's an additional agreement in which the investor can freeze the laws that were relevant for deciding its investment. And there is no limit here. So it could be health and safety laws, it could be environmental laws, it could be other human rights laws that are important, but that means that then this limitation of the state to take and to change laws in this area are limited by the agreement that is signed pursuant to this law. So we need to look across the board and see where are those limitations in terms of the regulatory framework and think whether they are unduly limiting the capacity of the state to regulate on human rights. The other element that is important that needs to be across also the board, and that's why we have this map at the beginning, we need to think about transparency in general. And transparency has two elements here. The first one is ability and access to information. So it's about having access to the contract that the investment, that the state is signing, and to the relevant documents that inform this negotiation, right? But it is also have ability and access to information about, for example, the negotiation of investment treaties. So we know, for example, that in TPP, the agreement that is now about to be signed and ratified by many states in the region, and I understand that Indonesia has made a statement about ratifying or accessing to TPP. The text was not released until very late in basically when it was already negotiated. So even though there were claims by the civil society and by others interested to have the text of the negotiation, it wasn't there. So all these, all these decisions and all these instruments and regulation that actually can have an impact on people's life at the end need to be also transparent. And this is the second part about openness of decision-making process. This decision-making process, if the state is committing at the international level to a certain number of things and obligations that need to be open for the population to understand what is the impact of those negotiations and of those possible commitments that the state is undertaking. It also helps in terms of transparency, also helps the investment climate, because investors also want to know and like to know what are the rules, how they are decided, and sometimes they also want to have a say in something that is going to have an impact on their own activity. It improves trust between government and citizens, and it can even improve the state's reputation among investors, and sometimes it has also an important relevance when when states are rated internationally for the way in which they are open to investment and how transparent they are with investment, so that they can also help with the grades of the state in terms of attractiveness for investors. And the last one, which I'm not going to get into much detail here because it's probably less relevant in the Indonesian context, but it is very important, the role of the state. when we are speaking about conflict and post-conflict scenarios. And it is interesting here to think also the role of the home state here, because probably the host state, because of conflict, is not in the capacity to be able to properly regulate and properly deal with investors. So there is a role to play for home states here to help also investors that are going to this difficult context to understand what are the risks and to take additional measures to deal with those risks. Because we know that in the context of conflict is probably where the most adverse human rights impact happen, where there is also a risk for companies to be involved in gross human rights violations. So this needs to be clear for investors, and if the host state is not able to help and to clearly regulate investments in this respect, then there is also a role to play for home states. And I think that's all about that. Yeah, I mean, that's also important for, as Andrea is mentioning, for Indonesians, if they go abroad and they invest in other jurisdictions, that might be difficult. So I don't know how many Indonesian investors probably are in Congo or are going to Colombia or to some difficult areas. And so that is something to think about also for the government in the way in which they support their own investors, Indonesian investors, going abroad. Probably the more clear, or the closest example is probably Myanmar, which is a country in transition where there are human rights issues, human rights violations. So it might be also an issue when the government is supporting those investors going there. How do they support and how do they make clear about the risk that these companies are probably taking in going to these kind of jurisdictions and this kind of context? So there is something to think about also in terms of the function of the state. It's probably relevant for the National Action Plan also to think about when the government, or the Indonesian government, is supporting and facilitating investments from Indonesian companies when they go abroad. Yeah? I don't know if there is any question? Yes?
Yeah, first, with regards to the words of expectation itself, I still have no clear idea when we are talking about the expectations, because the words really deals with the roles and the functions of the states and the corporations regarding the investments. Thus, those people who are having, imminent human rights violation, for example, individuals, group and individuals, or marginalized groups, do they also have something in common or share, equals expectations for their human rights adjudication as well as, human rights advocacy?
I think, a very good question. Expectations also have changed for everyone, I think, and from everyone. And of course, the idea is to integrate this expectation from communities that human rights are respected and are integrated into this economic activity. So the idea is that the expectation to respect human rights, which is also an expectation from the community, is integrated into the regulatory framework and into the dealings with the investor. So I don't know if that responds to your question.
But I think you're also talking about what expectations the communities have for the state, right? Yeah. And that is what changes. Actually, there were a few slides on that for time, I didn't show. But all it's showing, all it was talking about was that when I started this morning saying the world has changed because now the state is expected to be more active, there are expectations of communities, expectations of international organizations, expectations, it's the last slide here, expectations of international institutions, financial institutions, civil society, investors in business. All of those groups have new expectations for the state. And of course, community groups may not know about the UNGPs, and it's something that educating them about what is the proper role for the state that can help, right? Clarifying roles and responsibilities. Because often, what we also see, and we did a roundtable with investors in Colombia. So we had 10 national companies, but also international companies in Colombia, and we were talking to them about what are their human rights challenges. All of them said lack of information from the state and absence of the state. Because the absence of the state then created huge expectations on them that often, sometimes were appropriate, but sometimes were not appropriate, and the state was nowhere to be seen. And so I think one of the exercises that's interesting as we think about the National Action Plan is also, how do we set those expectations clearly? And how can we show the state, and also to community groups, how do we show that the state should be doing something here? And that means different advocacy in the National Action Plan, too, for what do we expect of the state there. And I think it's an excellent point, and it's something that there's been so much work on expectations of companies changing, but I think some forgotten discussion is what are the expectations of the state? Thank you for that.
I have a question regarding to transparency. But before that, I would like to ask whether you can actually explain just a little bit about the contract between states and company, because I've never seen that one, whether it's actually more in general principles there, or more general, or also involve nitty-gritty agreement, technical matters, there. I saw actually some contracts between the World Bank, ADB, with some companies, and they are very detailed. So my question is actually, if it goes to transparency, how far that the company basically, as well as the state, should be transparent to any contract, because so far it's only, it's only binding for the parties, not the third parties. But in this regard, I was just thinking like how far they both parties should be transparent to us, to the third parties, and if and when actually the best, based on your experiences, like before, during the negotiations, or even just the commitment, political commitment there already be a, of course we can always look at the newspapers, but and then how far until the implementations, and then the second of all, what kind of information should be given, because it can also backfires the investment as well as the company, investment as well as the state. And then the last one I forgot, but anyway.
Okay, probably when you remember you can ask the question again. But I think it's very important in the sense that, as Andrea was mentioning, probably in the phase of negotiation, it's very difficult that the negotiations be totally open for the communities. But what is very important, as was mentioned also before, is that both parties engage with the communities to understand what the concerns are, and these concerns are properly integrated into this negotiation. Then there is another phase, which is that of the signed contract, and that's something that we asking for. Where are those contracts? And now there is a kind of like a strong campaign around that, and many states are committing to have these contracts public. There is a website also that is being put by the World Bank and also a center in Colombia to try to create a repository of these contracts and give easy access to these contracts. Of course, some of the terms of the contract might not be, might be protected by confidential reasons, but it doesn't mean that you cannot probably delete this part of the contract, or you can black out this part of the contract, but the rest of the terms should be made public, and in particular those that are of interest to civil society. And then also some probably of the important documents around for the contract. So, I don't know, the commissioning agreements or some other documents that are important for the communities and for people to understand what is happening and what are the obligations between the parties, right? And then due to some implementation, I also think that implementation should be open for scrutiny to the communities.
Has anyone heard of the Natural Resource Charter? Yeah? No one. Okay. It's an initiative of Paul Collier at Oxford, and now it's managed by the Natural Resource Governance Institute, and it's called the Natural Resources Charter. And I was involved as a technical advisor, and what the Natural Resource Charter says, well, it used to say, I haven't looked at it in the last few months, but what it used to say, and I know that in our technical discussions we said this, that the contract should be transparent because it's your key to accountability. So it's understanding what your representatives have negotiated for you. But it's also accountability on what are the obligations of the company under that contract. But not only the contract, it's also the environmental and social management plans, baseline studies that are done in order to plan for those social impacts and environmental impacts. Those kinds of things, the Natural Resource Charter advocates for those things to be transparent. So there are a series of documents, and the contract may not even, to get back to the first question, the contract could be a simple license agreement, one page. It could be It could be a number of forms. Some contracts, I literally, a lot of state investor contracts that I see, at least in developing countries, are like this thick. Because unfortunately, a lot of the legal framework is actually drawn up and negotiated there, right? That's a problem. So those big contracts are then very important because they actually have the regulations involved in there. So what's transparent? It could be a wide range of things. There's a big movement on transparency now. So if you want other resources, I can tell you some other organizations, but the Natural Resource Charter is one. Yeah, and there are lots of documents, but it's about accountability. How can you make the parties accountable? What information do I need to make sure they're doing what they promised?
And in the context of investment agreements, there is also a big push on transparency because not only around the negotiations, and basically the negotiations of those treaties were never open. Even it didn't happen, because before it was just a model that was brought by some government official to a meeting that was then signed, and that was it. But now with, again, the discussion at the European level, they made the negotiations open, the text is open, and then the parties, the civil society are giving an opportunity to give their opinion around the negotiation. And there is also not only at the time of negotiation, but also the investment disputes themselves. So these investment disputes, as they were modeled on arbitration and commercial arbitration, was the principle is that it is confidential. So these arbitrations started to happen in the dark, basically. So no one knew that they were being filed, no one knew what was being decided, the awards were not public. But actually, since these awards have an impact on public interest and are going to be paid from our taxes, so then there is of course a reason to know and to understand what happened in these processes. So ICSID rules, or the Center of the World Bank for deciding these disputes, changed the rules in 2006 to make things more transparent. There was at the UNCITRAL level, which is the other rules that applied in arbitration. Sorry? This is something also, for example, for ENAC, to push for the use of these in UNCITRAL rules on transparency, which basically make these investment arbitrations more transparent. So at least there is the possibility for people to know what cases are being brought against the state. They also made some of the documents public. They also allowed, for example, for the hearings to be public, the intervention of third parties if they have an interest to bring to the arbitration. So that is also very important at that stage. So something to consider also in terms of the investment treaties. Is there any other question you want to ask?
Because can I just come back to expectations? Yes. I think that in most cases, so I don't understand why the question of the marginalized groups and the community comes, because in most cases I think the expectation of the groups of the community, they just disappear. So in most cases, in Indonesia, in most cases they don't exist. The expectation of the groups, of the marginalized, of the most effective groups. So how to reconcile the things? Because in most cases also the expectation of the state, the investor, and the groups, they are different. And how to reconcile the things? Is there any best practices how to reconcile the expectation of the different groups? That in most cases I think they are not same. There's some compromise. But how to do this?
In a specific project.
In a specific project.
I think that, there might be many expectations around what every party can benefit from a specific project, but in terms of, economic benefits or political benefits or the road to be constructed, so whatever it is, but I think that here the expectation is around not causing negative impact. So here at least it is, and I think it's the baseline expectation is that the project does not cause adverse impacts on the communities. So this is, I think that should be the first expectation to be agreed by everyone. So
actually, that's one of the most important things that the UNGPs did, I think, is they set out what should be the expectations of the state, what's the role, what should be the expectations of the investor, what's the role. Now, that's in a general sense, right? So it sets this platform where everyone has to agree. The state has the duty to protect, the company has a responsibility to respect. do not have negative impacts, address those impacts that you have. And it tells you, how do you impact? You impact directly, you impact indirectly, you impact, could be directly linked, right? So there are three, right? Cause, contribute, or directly linked. So the UNGPs even tells you how you could impact. So that has to be the basis of the conversation. Now when you get, and that has to be what's integrated in legislation, right? Companies will accept it, states have accepted it, so that is the value. Unless you use that, you're not getting the value of the UNGPs, right? Because it sets, that is the discussion. It sets the expectations, differentiated roles, and we know what your responsibility is if you're a company, what your duty is if you're a state. But then, when you get into a specific project, so when you're talking around, what does that mean? What does that mean, okay, you're going to have this impact and we want you to mitigate it in this way. That's about the engagement process that happens. Now, whether you can create, there are best practices around creating platforms for discussion or community development agreements, and I'm not sure in Indonesia if they're required. Are community development agreements required? So, and I don't know about Indonesia and how those are used, but that is a platform for setting out expectations and a platform for agreement, community development agreement.
It is there, but it's not implemented very well.
Okay, so maybe that's something that we talk about for the NAP.
Actually, I have the same concern with Mbak Roy, but I'm not talking about the specific project, but I'm asking about the principles. Where is the involvement of society in these principles? Because in all the principles, like you mentioned, like the key issues, there is no point where the society will be involved in implementing all the principles. Yeah, that's my question. Thank you.
But I'm not clear what it means, society enforced.
I mean, like, for example, like in the key issue number 2, like expectations, you mentioned that the investor needs the clear expectation. What does the state expect from the investor, from the corporation, like that? But I mean, does this principle, do the principles also mention about, do the principle regulate how the state should be proceed the expectation from the state to extract the expectation also from the society, from the affected society? So I don't know, I just wonder where's the society interest in these principles can be involved. Thank you.
I mean, it's a really interesting point, and there are two answers. The first is the state is under its obligation under international human rights law, right, to protect, respect, fulfill, promote human rights, right? So it is not the case that every time a state makes a rule or makes a law, it has to hear from society, what do you expect? Because the baseline is already there, right? The baseline is there. You have to, okay, can you as a state allow that company to throw its wastewater out without treating it and without regard to where that water goes? No. Because the state is under an obligation to protect human rights and respect human rights, and that water might be dangerous for people. So we already know that the state should be regulating where that wastewater goes. Right? Now, when you get to particular issues of a particular community about what that means in context, there may be space in the community development agreement context or in another context to talk about specific expectations. Okay, we want the wastewater done away with in a in a positive way. Now, does that mean putting it here or putting it there or doing something else with it that the community might prefer? Now, that's at another level of specificity. But if we're talking about regulation that should be applied nationally or locally to all investors, you already know what the baselines are. Now, they may fail to live up to expectations, but then that's a democratic process to be saying to the state, actually, you don't have good wastewater legislation, and you need to be doing that because under your human rights obligations, you need to be regulating where wastewater goes. Right? But it's not the case, and I don't think it's workable, that in every single rule the state would make, and every regulation, and every also environmental management plan requirement that they hear from communities, because actually every community might say something different also. Right? So you have the baseline, and the UNGPs are called the baseline expectation. Now there could be other things, right? There could be other things that the state says, you know what, we need this project to spur development. So what we're going to do is we're going to require X, Y, Z, other things because this community wants to do X, Y, Z. Well, that's a negotiation that's a discussion between the state and the communities. But what we're talking about here are regulations, the general rules that should be in place for every investor, not specific. And in the contract area, there is this room for a discussion with the communities. And what we said was the state should be going out and understanding the human rights issues before they go into an investment contract, right? So that's a space.
I'm just wondering if there is one corporation or the investor, like they have a good faith, good faith investor, and then they want to make a contract between one state, and then the state doesn't imply to the human rights standard, So what can the corporation do to that problems? Because in point 5 of the key issue, like transparency, actually it's already mentioned about the improved trust between government and the citizens. But what the implication if that if that indicator doesn't imply by the state? Can the corporation, the good faith corporation or the investor, like, no, I don't want to make a contract with you, or what is the like the sanction? Can be like, is there any sanction whether one of the party doesn't imply to the the key issue mentioned in these principles? Yes, yeah, like that.
Okay, well, first of all, the paper you have in number 5, it's about the NAP, so it's about government. It's not about companies, because the discussion here is really about the state, and it's about what can we put in the NAP. So the company stuff is not there. That's why you don't see that. But of course, as advocates, you use every lever you can. So if you can use the company as a lever for better behavior of the state, you do it, right? And so, I mean, we talked with a lot of investors who want international human rights law and humanitarian law cited in the contract because they want to make sure the state does the right thing. Or, it's not only the state, it's also their contractors. So they were very happy for international best practice and the laws of the state, and then other voluntary standards, but to be put in the contract as contractual obligations, because they said, my industry, and this was oil and gas, my industry is basically carried out by contractors. But if I have the obligation to commit to all of these standards, then I can very easily pass it on to my contractors. And I'm not doing it, it's the state that required me to do it. Right? So they use that as a tool. Now you can do the same thing for the state. So if you look, and I know the Liberian contracts, I know that there are examples where they say the physical security for this project is going to be in line with international human rights law and humanitarian law, and actually there's going to be a plan of training for physical security, et cetera, and lays it all out in the contract, it's a contractual requirement for the state. So you could, as a company, have a state claim. You could have a state claim as a claim against the state for contractual breach if they don't do the right training, if their police officers detain people for more than 24 hours without giving them over, et cetera, et cetera. So you can put all those things into a contract, of course, to use it as a lever against the state as well.
And to give a bit more weight to these principles and standards, because a lot of things that what we hear is that, yeah, but there are principles, they are not obligatory, they are not compulsory, but actually there are ways in which you can actually make them enforceable. Because at the moment they are part of your contract, then you can enforce certain things against the state or against the company. So that's also a tool, it's just a tool that you have there to think about. You wanted to probably share something about the treaties?
May I speak in Bahasa? Because
Just give us a second.
my English is not very good. Sorry. Thank you. Saya Rahmi Hartanti dari Indonesia for Global Justice. Mungkin saya sedikit diri. Sebenarnya diskusi hari ini cukup menarik. Tadi sedikit permintaan dari dia untuk share sedikit dari Indonesia for Global Justice terkait dengan investment treaty. Mungkin dari beberapa diskusi kita tidak terlalu banyak menyinggung terkait dengan investment agreements, tapi paling tidak sedikit banyak pengaruh terkait investment agreement terhadap persoalan bisnis and human rights cukup besar. Karena kalau tadi sudah menyinggung terkait dengan beberapa persoalan yang ada di dalam investment agreement seperti standar protections-nya investasi asing di Indonesia dan sebagainya, kita tahu bahwa praktek perlindungan investasi asing di Indonesia itu dimuat di beberapa hal. Pertama itu dia terkait dengan penandatanganan bilateral investment treaty. Mungkin teman-teman sudah pernah dengar bilateral investment treaty, kemudian juga free trade agreements di beberapa hal. Kita sudah menandatangani ASEAN Comprehensive Investment Agreements kecil, yang di dalamnya juga terdapat beberapa klausul terkait dengan investment protections dan standar investasi, perlindungan investasi, dan di dalamnya juga memuat salah satunya adalah mekanisme dispute settlement yang adalah satu isu yang paling krusial dalam investment agreement. Selain itu, Indonesia juga sedang menegosiasikan beberapa free trade agreements, seperti salah satunya adalah ASEAN Regional Comprehensive Economic Partnership, yang di dalamnya juga memuat investment chapter. Di situ juga memuat standar perlindungan investasi asing dan mekanisme investor state dispute settlement. Dan ke depan Indonesia juga sepertinya akan memulai putaran perundingan EU-Indonesian Comprehensive Economic Partnership Agreement, yang di dalamnya juga memuat investment agreement. Bahwa hari ini tren free trade agreements itu tidak lagi hanya bicara terkait dengan konteks perdagangan, ekspor impor, tapi sekarang trennya juga sudah bicara tentang bagaimana isu investasi, kemudian juga terkait dengan isu services dan kaitannya dengan intellectual property rights. Tapi paling tidak hari ini sepertinya pemerintah mulai menyadari beberapa hal. Karena konteks mekanisme investor state dispute settlement adalah salah satu mekanisme yang sangat-sangat merugikan Indonesia. Karena tadi sudah disebutkan, dengan adanya mekanisme ini, paling tidak pemerintah seperti di bawah kendali atau tersandra lah oleh investment treaty yang sudah ditandatangani, sehingga tidak mempunyai ruang yang cukup besar untuk membuat satu pengaturan-pengaturan yang paling tidak dia dalam konteksnya adalah melindungi kepentingan nasional. Karena ketika ada terjadinya perubahan peraturan perundang-undangan, potensi bahwa Indonesia akan digugat ke lembaga arbitrasi internasional itu cukup besar. Mungkin ada beberapa kasus yang sudah pernah kita alami, salah satunya adalah Mimon, walaupun akhirnya di withdraw, tapi paling tidak itu bukti bahwa sebenarnya kita ada di bawah ancaman, bahwa regulatory space yang dimiliki oleh pemerintah hari ini adalah dia bisa dikatakan bahwa kedaulatan kita dalam mengatur negara kita sendiri itu di bawah ancaman investment treaty. Sehingga saya pikir diskusi cukup menarik karena misalkan inisiatif pemerintah untuk melakukan review terhadap bilateral investment treaty, kemudian dia menghentikan sampai hari ini sudah sampai dengan 20 investment treaty, bilateral investment treaty, tapi proses penghentian itu tidak menutup kemungkinan perlindungan itu tetap berlaku karena setiap bilateral investment treaty itu dia memiliki survival clause, di mana walaupun itu sudah dihentikan, itu tetap berlaku bisa sampai 10-15 tahun mendatang, walaupun itu sudah dihentikan. Itu namanya survival clause. Nah itu adalah standar yang ada di dalam perlindungan investment treaty. Nah persoalannya adalah ketika pemerintah melakukan review terhadap bilateral investment treaty, kemudian itu akan menjadi satu draft template perundingan investment chapter. Pada hal yang sama mereka juga sedang menegosiasikan ASEAN-RCEP yang juga sedang menegosiasikan investment chapter. Nah satu sisi adalah ada beberapa hal yang investment chapter sudah disepakati, ada beberapa hal yang sedang dinegosiasikan dan sedang direview, tapi sampai hari ini saya belum melihat bahwa pemerintah bahwa draft template yang didiskusikan hari ini akan digunakan di beberapa negosiasi free trade agreements. Artinya sebenarnya inisiatif review itu cukup baik, tapi saya tidak tahu bagaimana dampaknya terhadap beberapa free trade agreements yang sudah disepakati dan yang akan dinegosiasikan ke depan. Sehingga apakah artinya kita perlu ada satu mekanisme yang diberlakukan terhadap beberapa free trade agreements yang sudah berlaku yang di dalamnya di investment chapter untuk menarik kembali komitmen pemerintah Indonesia terkait dengan investment chapter. Karena ini yang paling penting kuncinya. Bagaimana pemerintah Indonesia bisa menarik kembali komitmennya terkait dengan investment chapter. Saya tidak tahu apakah mekanisme sudah ada, karena memang ini cukup bahaya. Yang kedua persoalannya adalah ketika hari ini perjanjian internasional kita berlaku, bahwa persoalan perjanjian internasional itu adalah terkait dengan besarnya kekuasaan absolut pemerintah dalam menandatangani setiap free trade agreements. Ini menjadi persoalan. Mungkin ini bisa menjadi salah satu kunci ketika pemerintah Indonesia melakukan berbagai diplomasi ekonomi internasional kita. Karena praktis dengan adanya perjanjian internasional ini tidak ada satupun konsultasi terkait dengan free trade agreements yang sedang dinegosiasikan oleh pemerintah itu ke publik, bahkan ke DPR. Itu tidak ada. Setelah sign, dia baru dikonsultasikan. Buat apa kan gitu? Bahwa itu sudah berlaku dan kita sudah akan menerapkan free trade agreements itu. Artinya memang hal yang detail di level nasional memang cukup penting, tapi kita perlu juga memperhatikan beberapa hal yang hari ini sedang berlangsung di level global, seperti penandatanganan free trade agreements, dan yang kedua adalah terkait dengan review bilateral investment treaty yang dilakukan oleh pemerintah hari ini. Karena walaupun Indonesia sudah menghentikan BIT dengan Belanda dan lain sebagainya, nampaknya ke depan itu beberapa negara Uni Eropa tidak akan melakukan negosiasi secara bilateral, tapi dia akan memasukkan investment chapter itu ke dalam negosiasi EU-Indonesia SEPA. Artinya memang ini menjadi penting ya, apalagi kemudian ada isu bahwa pemerintah akan berminat gabung di TPP, yang salah satunya adalah investment chapter. Saya pikir penting bagi kita mungkin dalam mendiskusikan National Action Plan ini memfokuskan satu sisi itu pada isu-isu di seputar free trade agreements dan investment chapter. Saya pikir itu catatan.
Thank you very much, and I think that's probably something to keep for then our discussion this afternoon, because it's very specific to the Indonesian context and is the position that the Indonesian government is taking then with respect to these agreements, free trade agreements and the investment agreements. So I invite you that we keep these in mind for the conversation this afternoon, and that we go for lunch. If there is no other question.
We'll have our right to food.
Your right to food being upheld here. Is downstairs. So downstairs, so we go to the restaurant downstairs?
Yes.
So you take here to the left, go downstairs, and it's in the restaurant. And let's come back at 1:45. Yes?
And be ready
Thank
to
you.
work.
Yeah. So take energy, eat well. You're going to be working this afternoon. Thank you.